Okay. State of Michigan versus Christopher Hurst, 21S00395.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Christopher Hurst.
State your name, Mr. Hurst. Christopher Hurst.
Thank you. Mr. Hurst is here for a pretrial and a bond violation.
That is correct, Your Honor. I could not find what the bond, I'm unsure what the bond violation is.
Let me see if I have something here.
I told her, sign on to Zoom at 10 after 11, and she can explain herself. Gotcha. Last time I went to a court, they almost took me into custody at that fact because you don't listen. So,
Looks like the bond violation was failing to appear for the court date. I knew. He just, when the magistrate arraigned him, she said pretrial and bond violation, but I think it was just a failure to report on January 10th, 2024, which is a bond violation technically.
Okay.
There won't be, we don't need to have a hearing on that.
Okay. Unfortunately, I was not able to get in touch with Mr. Hurst as far as the pretrial today. If I could have a quick breakout room, or we can adjourn, whichever, Your Honor.
I'm gonna give you the adjourn date. And
Okay.
then put the breakout room with him.
Thank you.
July 1st, 2024 at 9:00 a.m.
my guys are illiterate.
Forum will be continued. We'll put you into a breakout room, Mr. Hurst, so you can talk to him at this time.
Thank you.
And because it's been special ed since he was
State of Michigan versus Nicholas Sanford, case number 22S00276.
Rachel McDuffie for the people.
So I'm getting some of that. I'm getting some of the records delivered to me this morning. Okay. So, yeah.
All right.
We need Mr. Hurst to stay here. Can you ask him to come back, please? Darn it.
Assistant Public Defender DqSd5OMivgo for Mr. Sanford, and from Sanford's information, I'm currently filling in for Ms. White. Mr. Sanford, can you state your name?
Mr. Sanford,
Yes, it's Nicholas Sanford.
thank you. All right, it looks like Mr. Sanford has been doing some things right, some things not quite right. Mr. Sanford has not reported any of his 12-step meetings, so it looks like he's not going. If he doesn't have any report showing by the next time, a violation will be filed against him. You need to report every month, sir. You missed the reporting for the month of April. Do you understand?
Yes, ma'am.
So are you going to your meetings, your 12-step meetings, sir?
I've been going to some, but it hasn't been any consistent string of me going. I've just been trying to get my schedule down with the random testing, the growth works. I've been hitting every counseling session though. I haven't missed a counseling session with growth works. And I've been having group meetings on Mondays with them and personal one-on-ones on Wednesdays. But I haven't been going to any side meetings consistently, but it's something my counselor has been on me about recently. So I just got a sponsor and we working on that.
Well, so you need to be going. If you aren't going, you're going to be violated. You can do jail time. You understand?
Yes, I understand.
Anything from the people?
Nothing from the people around.
We'll see you, Mr. Sanford, on August 5th. If you're not in those providing meeting sheets at that time, then you can do some jail time until you figure out that we're serious about it.
Yes. Thank you, Aaron.
You're welcome. We'll see you on August 5th.
Thank you.
You're welcome. State of Michigan versus Lori Williams, case number 23 FB 2426.
Rachel McDuffie for the people, and we also have a pretrial for Ms. Williams as well.
And the court will call the matter of the State of Michigan versus Lori Williams, 24S00172.
Assistant Public, I'm sorry,
I just said Rachel McDuffie on that one too.
Assistant Public Defender Sandra White on behalf of Lori Williams.
Ms. Lori Williams, please state your name.
Can you hear me now?
I can.
Okay, Lori Ray Williams.
Thank you.
Yeah.
All right, what are we doing on the pretrial? Let's start with that.
I believe 23 FB 246, is that actually a sentencing? I see Ms. McDuffie shaking her head, yes.
Yes.
Okay, as far as the pretrial on 240172, we need to adjourn. I think Ms. McDuffie did get back with me and say there was no offer, but I had already met with Ms. Williams on that one, so I need to adjourn to discuss that further.
Well, I'm not proceeding with the sentencing until we have both cases have caught up one another.
Okay,
And Ms. White, I guess I should clarify. So there's no offer because the case was really undercharged to begin with. But since Ms. Williams is up for a sentencing in our court, essentially it would be an offer of no upfront jail with concurrent sentencing on that case, should she plead to the misdemeanor pretrial.
I think I understand.
Basically, no upfront jail.
Okay. I'm
Further.
sorry, okay, I'm really ill today. I'm
Me
hanging in there. Oh, you too.
All right, so we'll adjourn the pretrial. We can move it to June 24th. If that's the earliest. Well, I can move it to next week. Do you think that will give you enough time?
Yes.
All right, June 10th, 2024 at 9 a.m. Bond is
Yes.
continued.
Actually, can we discuss bond? I think she has a PR bond with home confinement, but we're unsure why she's still in.
Your Honor, and Ms. White, so there are two things. The first thing is that I know that there was an issue with her home confinement address. She apparently attempted to change that, I think through the PD's office, and reported that some wires got crossed somehow, and so the correct address was not on file, and that was reported as a violation. That is just my observation of her arraignment on that issue, so that's what I recall hearing. But the second issue is obviously the other case, because that offense date is just last month, which is why she was on bond for the previous one. That offense took place right after she entered her plea at the before Judge Simpson. So I think there's two bond violations that are at issue.
So
Well,
you
we
think the other case is keeping her in custody?
I believe so. Let me just make sure.
I understand we have an address issue. I believe that the person with respect to the address did reach out to community corrections, though, you know, from what I read in the report. Has that changed, Ms. Johnson?
No, they did reach out to community corrections. I believe that the only component is Ms. Williams' transportation to the residence because someone has to physically pick her up from the jail.
I see.
I have a
Great. Well, maybe it's the other case that's still holding her. If that case is holding her, she can't go anywhere. But on this case, it looks like she's free to go. So we'll let them work that out with her as a case. Sentencing in this matter will be adjourned to June 10th, 2024 at 10 o'clock. No, I'm doing them at both at 9 a.m. on 23 FB 2426. And the pretrial is adjourned to that same date and time.
So just to clarify, on 24-172, does she have a home confinement tether on that one also, or no?
Cases.
I'm sorry,
No, I think she just has straight PR on that one. On the
straight,
on the sentencing case. Which one did you ask about?
the new case.
That's the one she has the home confinement.
Okay,
The
Can I state something after you guys figure that out?
other case.
okay.
Like to say, Ms. Williams.
Oh, I didn't hear, you said the one case was a straight PR. What did you say for the last thing you said for the other one?
The other case is straight PR.
And then the other one is the home confinement. So Mr. Benak, when I was still up in ITR, he said he was waiting on an email from you, okaying the address. The 1726 Laurel Bay Drive, and because my tether's dead and he has to replace it before I can leave. But I do have transportation out of here. I've already contacted and it might not be until 5-ish tonight, but I do have transportation.
Well, apparently, first of all, they don't talk directly to me. They talk to probation, and probation has said that has been approved. So
Okay,
that's been approved. So that's not what's holding it up anymore, ma'am.
okay, all right. We were just a little confused about that. I didn't know if it was you or probation, but thank you for clarifying.
You're welcome.
So everything's all set to get up out of here? We're
Yes,
just
you are.
waiting.
As
All
far
right.
as unless the other case is holding you, ma'am, like I said, I don't have any control over what's going on with Judge Simpson.
Oh, no, Judge Simpson is, I pled down, I'm not seeing him anymore. I pled down with him, signed a plea agreement with Joy Gaines and, the prosecutor there, and they had sentencing before you.
It's here. We have a PSI for that case, Your Honor.
Yeah,
Okay. So that's the one that's Simpson. Okay. All right. Thank
so I
you.
got a PR for one and home confinement PR for another.
Correct.
All right, thank you, ma'am.
Thank you. All right, the court will call the matters of Muhammad Diane, case numbers 21W00731B and R, as well as 23W001986.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Liebo on behalf of Mr. Diane. Mr. Diane, could you unmute, start your video, and state your name, sir?
Mohammed Diane.
Thank you. Mr. Diane's here because he's supposed to be making payments. Has your client made any payments?
If not, Your Honor, Mr. Diane has explained to me that he recently started a new job and he has not yet been paid from that job, and therefore going to be requesting a 30 to 60-day adjournment for him to begin making payments.
I started at CHS Home Care.
Okay. July 24th at 10 o'clock a.m. Sir, you should be making payments by then. We've been doing this a long time with no payments.
No, I have it paid by then.
All right, July 22nd, 2024 at 10.
Thank you.
Thank you. Have a good day. When did I send them to you? If you tell me that, I'll just tell them to you. Mr. Wolf, I rescheduled your matters to oh, I'm sorry, you came all the way here for that. I rescheduled all your matters to September 16th. We found out that you had made some payments, sir. So we moved to September 16th, okay, at 10.
I'm trying to do what you want me to do.
Yes.
I'm trying.
I see you did, sir. Thank you. Sorry you
All
had
right.
to go all the way here. All right. Thank you. You too. State of Michigan versus Gabino Francesco, case number 23S00546.
Rachel McDuffie for the people.
Deborah Schlossel on behalf of the defendant, Mr. Gabino Fonseca. Mr. Fonseca, please state your name.
Gabino Fonseca.
Your Honor, today is the date and time set for sentencing. We have reviewed, my client and I have reviewed the sentencing recommendation. We have no additions, deletions, or corrections. My client would like to say something to the court. He is very remorseful. He knows he made some bad choices and he needs some help with alcohol treatment. Mr. Fonseca?
All right, Ms. McDuffie?
Thank you, Your Honor. I always appreciate, because I think it happens rarely, that we read in a report that a defendant made no attempt to minimize or downplay the severity of their substance abuse problem. And it's clearly an issue here because this is a high BAC second offense. Not just second offense because it was the second case that happened, but I think the actual second high BAC after a first high BAC as well. So the circumstances are clearly very troubling, but I do appreciate that Mr. Fonseca has the insight that is going to be needed at the very start to try to get some sort of handle on this. So I agree that he obviously needs to engage in the treatment that's recommended. I am also happy to see that, as far as I can tell, he hasn't had any violations on the scram tether, if I'm not mistaken, since he's been on. So things are at least looking up at the start. So
He has had no, oh, I'm sorry.
No, I thank him for that.
He has had no bond violations, Your Honor, and he's complied with all the bond conditions and shown up to every court date. He's the one that's been early. I'm the one that's been late.
Thank you. Appreciate that. Mr. Fonseca, I understand that you have something you would like to say. You may at this time.
Mr. Fonseca? He's muted.
Hello?
Your Honor?
Hello? Yeah?
Yes, we can hear you.
Okay. I'm sorry. I didn't, my phone was on mute.
That's okay, sir. What would you like to say?
I would just like to say that I'm sorry for everything that happened, and I'm really, really committed to do whatever everything you say, and I'm apologize because I was pretty bad and I'm driving and drinking at the same time, and I was completely reckless on my behalf. I'm just so sorry for that, and I'm gonna do whatever you tell me to do. I will do it, and any program you put me in.
I too am very happy to hear that, and I hope that you follow through and that these services work, because it seems like you need help, and I'm hopeful that that will work out for you. I have put her back in the waiting room because she keeps on muting. It is the sentence of this court that you serve 365 days in the Washington County Jail, credit for 1 day served. The 364 are suspended. You are on to do 7 days for a total of 50 community service, 18 months of probation, fines and court costs in this particular case for a total of $1,235. You are to complete $30 per month probation oversight fee, complete an assessment at 616 SUDS, and follow all the recommendations, sign a release of information for the probation department, and schedule that assessment within 1 week of today's sentence. You're to attend the MAD Victim Impact Panel within 45 days of sentencing and provide a certificate of completion to the probation officer. you to report to probation officer monthly. That's on an online reporting platform. So make sure you go on every month and make that report. You're gonna meet with
Okay.
you're gonna meet with probation when and where directed, including any and all home visits. There's no use, possession of alcohol, marijuana, drugs, drug paraphernalia, weapons of any sort, including firearms, firearm components, ammunition, or any other dangerous weapons. And you're to be in the presence of no one that is using any of those items. You're to drug and alcohol test 3 times per month, and any other times as ordered by the court, probation, or police agency. And they attend 12-step meetings 2 times per week and provide proof of attendance to the probation agent. We're going to do a review in this case with the probation officer on September 6th, 2024, and that's going to take place via Zoom at 8:30 in the morning. You understand?
Yes, sir.
I'm sorry, Your Honor, can you repeat the date of the review?
September 6th at 8:30 a.m.
And that's via Zoom as well, correct, Your Honor?
That's my understanding, but it doesn't technically say that right there. Ms. Straub, are you present?
I am, Your Honor. Good morning.
Good morning. That's via Zoom at 8:30 a.m. with you.
It could be either via Zoom or via telephone, Your Honor. That's why I left that part off.
Okay, all right.
Oh, Your Honor, that's with probation and not with the court?
That's correct.
Okay, so I'm not required for that, correct? Okay.
You're not required for either of them, but that's between you and your client.
Right. Your Honor, which is the review before the court? That is the one I'm interested in.
We don't have a review before the court. It's going to be before the probation agent next.
Okay, all right, thank you.
Please call the probation department tomorrow after 9:00 a.m. Sir, do you have their telephone number? Did you write it down earlier? You may not have been on the call, actually.
Your Honor, I'll write it down and give it to him. What is it?
734-483-7336.
Okay, thank you.
All right, thank you.
Thank you, Your Honor.
Have a good day.
Thank you, you
Thank
too.
you.
State of Michigan versus Gabriel Curtis, case number 23S00787.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Gabriel Curtis.
Mr. Curtis, please state your name.
Gabriel Curtis.
Thank you. We're here for the motion that has been filed by the defense in this case to withdraw the plea. Do you want to make any arguments at this time, Ms. White?
Your Honor, I do rely on my motion. I know the court was unable to open the medical records from the jail. I did attempt to try to send them over again in a different format. So I don't know if you want to adjourn for me to try to send those over again, or if you just want to go forward today.
All right, I'm gonna hear Ms. McDuffie and then we'll go from there. I will, go ahead, Ms. McDuffie.
Thank you, Your Honor. Yes, I was not able to open those as well. I don't know if Ms. White already tried to send something else, but I don't know if they will necessarily make a difference in what my arguments were. So I will rely on those, but I did want to, I know I brought to the court's attention and Ms. White's kind of offline late last week, but in the process of responding to this, something a bit odd came to my attention. And I guess I just wanted to, we may need to adjourn in case we need to call or somehow address the township case because Mr. Barnett's case with the same victim, he had an assault and battery case. We took the pleas together, literally in the same hearing at the same time on both of these cases. And it looks like there was some kind of mix-up that resulted in that case reverting to pretrial status. It was then set for a bench trial and dismissed. I was not sure if the court at some point granted a withdrawal of that plea or if it was literally just some sort of error that happened along the way. So because that is contained in the same transcript for this response, if that's something that we need to address or look at, it may make sense to adjourn and perhaps call both of these cases together. If there's anything that we need to do with that. I brought it up because not only did I observe it in the transcript, but I was just curious about whether there was some sort of request granted that I would, that would factor into this motion. Other than that, Your Honor, Again, no objection to an adjournment, but I do not believe that, I understand Mr. Cardis has had a medical situation that has changed and I believe deteriorated since the plea was entered. And I think we're all aware of that. But I don't believe that there is a basis to withdraw the plea that was entered at the time that it was, just based on the speculation that some of the things that he has been dealing with may have impacted him. And I think that the transcript shows pretty clearly on just what level of comprehension and intelligence, voluntary, the nature of that plea. I think that the transcript really illustrates that. So I'll leave it to the court in terms of how we move forward from here.
Thank you. I do agree with the prosecutor for the most part with respect to this matter. I think that the transcript does show that, but I do want to look at the records to see if there's something in those records that would dissuade this court. In addition to that, the main issue that I have here with the motion that you filed, Ms. White, and you may want to figure out how to address this when you come back, is that there is a two-pronged process, and you only address the first prong. How would this be a manifest injustice? Like, does he have a defense? We don't hear any of that. That is the motion is devoid of that piece of the process, the prong. So,
Okay.
we could do this on June 24th.
That works for me. Thank you.
And you're gonna get us records that we can open.
Yes, we're going to work on that. Hopefully I can get that to you this week.
Adjourned to June 24th, 2024. I'm gonna make it at 11 o'clock a.m. for a motion, for the motion hearing. Bond is continued. And what's the other case number?
Oh, the township case?
Yes.
One moment, I gotta grab it. I was copying and pasting it so much in the motion and now I don't have it pulled up.
Let's be right in here. Wait 1 second.
It might be in a footnote at the bottom of like page 2 or something.
Yes. No, it's 23T00516 to be added. All right, we'll see everybody that day. Mr. Barnett, your case will be back on that day as well.
Thank you. Yes, I haven't had a chance to look into all this, so I appreciate it.
All right, thank you. You're all set, Mr. Curtis.
Thank you.
State of Michigan versus Santana Taylor, case number 23 FB 1072.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lebo for Mr. Taylor. Mr. Taylor, can you state your name, sir?
Santana Taylor.
Thank you. Mr. Taylor failed to schedule his PSI appointment.
Yes, you know, we had stuff going on in the courtroom. I got confused about everything, and I didn't even know I had to do all that because my attorney only put 2 court dates on there, but he never wrote down the PSI part. So he put the Zoom meeting. I know I had the Zoom meeting for today, then I got the one for tomorrow at downtown Ann Arbor, and that's all he wrote down on a piece of paper. So, you know, so much stuff going on that day that I didn't even remember how to do a PSI.
And that previous attorney was not me, so I cannot speak to that, Your Honor.
All right, I'm gonna adjourn this matter.
Okay.
July 1st. Wait, let me see. Yeah, July 1st, 2024 at 10 a.m. Referral fee on.
Excuse me. Sorry about that.
You are supposed to pay a $60 re-referral fee. I'm gonna take that under advisement to see if I'm gonna make you pay it. I'll decide at the time of sentencing.
Okay, so do I call up there today for the PSI?
Call tomorrow, sir. Do you have the phone number?
Yes, I gave it to, do you need it, my number?
No, do you have the phone number for the probation department?
Yes, I do, yes.
All right. Call them tomorrow after 9 a.m.
All right, thank you.
Thank you. Woods Lane Township versus Angel Martell. Case number 23T00381.
Paul Barnett on behalf of the township.
Assistant Public Defender Donnie Lieb on behalf of Mr. Martell. Mr. Martell, could you have him unmute you and then state your name, sir?
Mr. Martell, did you ask them to unmute your device, please?
Mr. Martell, could you state your name?
Angel Edward Martell.
All right. We're here for a bond violation and a pretrial.
Yes, Your Honor, with regard to the bond violation, Mr. Martell will admit to it.
Bond violation, sir, it alleges apparently never stood at community correction. Is that correct, sir? Oh, well, first of all, do you intend to admit to the violation?
Yes, Your Honor, that is true.
Please raise your right hand and be sworn. You swear or affirm that the testimony about the Bible is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Sir, back in July of 2023, you were ordered to test at community corrections within 24 hours. It appears that you have never tested. Is that correct?
Yes, Your Honor.
Are you satisfied, Mr. Burnett?
Yes, Your Honor. Thank you.
Defense is likewise satisfied, Your Honor. Thank you.
Mr. Lebo, as to the pretrial.
Your Honor, with regard to the pretrial, we'd like to set this matter for final settlement conference.
Final settlement conference, July 25th, 2024, at 11 a.m. Jury selection, August 9th, 2024, at 8:30 a.m.
Thank you, Your Honor. We would also like to address bond.
You may proceed.
Thank you, Your Honor. Mr. Martell is seeking a release to either treatment or home confinement. He tells me that currently Avalon Housing is working on finding an apartment for him. Additionally, he's looking into treatment at Dawn Farm. He tells me that if he's released, he has no objection to being on a tether, and then he will not test positive for anything except for Valium that he was given by jail staff and marijuana.
So he doesn't have a place he could be confined to?
Not at the moment, Your Honor. And I did explain to the court, may I?
Your Honor, I will in 3 weeks, roughly.
I see. Mr. Barnett?
Your Honor, I'll leave it in your discretion. I mean, obviously it's a concern if he's going to be home confinement, he doesn't have a place to go at this point. I'll leave it in your discretion.
Defendant may be released to treatment. Mr. Lebo, I will consider a home confinement once he gets an address.
Thank you, Your Honor. Mr. Martell, once you have that address, please give the public defender's office a call and ask for me.
Okay.
All right. Hopefully he can get into treatment or into that home confinement before then. I don't want him sitting there until July, so. But let your attorney know as soon as you find a place that you can be confined to, okay?
Absolutely.
So, Your Honor, if I end up finding an address as soon as possible, I can be tethered to that address as soon as possible?
Yes, sir.
Okay, thank you, Your Honor. Yeah, blessed one.
You too. Michigan versus Stefania Ramirez, case number 24S00100011.
Rachel McDuffie for the people.
Assistant Public Defender Don Filippo for Ms. Ramirez. Ms. Ramirez, could you please unmute and state your name, ma'am?
Estefania Ramirez.
Thank you. We're here for sentencing today. Have you an opportunity to go report with your client?
I have, Your Honor. I would say that I agree with every word of the report, as does Ms. Ramirez.
Thank you. Ms. McDuffie.
Thank you, Your Honor. I can appreciate that this is obviously not the worst set of facts that we've ever seen in this court for OWI case, and that Ms. Ramirez does not really have any criminal history, and that she was looks like for the most part, not a terrible driver prior to this. What concerned me though was it's a progress report. It's dated May 30th. And I don't think I've ever seen such a consistent pattern of she's alternating ETGs and PBTs, but there's a mistest and then there's a makeup test that's negative, but it's like 1 or 2 days later. If not, yeah, it looks like that's been the pattern since pretty early on. And that gives me some pause, because I don't want it to be the case that something's not being detected. I know that from time to time, something comes up and people have to, people may go in for an unscheduled ETG or something just to kind of confirm, no, I haven't been drinking, but I've never seen a pattern like this where just back to back to back to back, the assigned or, random date or whenever they're called in is missed. And then it's made up days later when something may at that point be out of the system. So that's my hesitation. That's my concern. I'm not sure really what's behind that. And I'm not clear on if the recommendation was also stating that testing should be discontinued, because I disagree with that if that's the case, based on what I'm looking at in this report. I don't know that we actually have a clear picture of what's really going on.
Thank you. Mr. Lebo.
I do have the progress report that Ms. McDuffie is discussing in front of me, and I do see that there have been some missed samples. I would note that Ms. Ramirez is regularly having ETG testing, which I believe would pick up any drinking. I'm not aware of the reason for the missed samples. However, there does seem to be some more consistency later on, and there has never been a positive.
Thank you. Ms. Ramirez, what would you like to say, ma'am?
Did you mean like just in regards to the mistests or the
recommendation and then to the mistest?
I'm sorry, I missed the first part that you said.
Both.
Oh, okay. In regards to the mistest, I do work an hour away, so sometimes it's just hard to make it to the testing site by 4:30 when they close the doors. So I have been like in contact with my supervisor, and she just tells me that it's okay that I can go in the next day to get tested. And just in regards to the violation, I did want to apologize and hold myself accountable. I do recognize that I should just be more responsible, especially being in like a college environment where there's like a lot of drinking and stuff going on. I just do want to hold myself responsible and accountable in terms of the violation.
Thank you. I'm going to follow a recommendation for the most part. It's the sentence of this court to serve 93 days in the Washington County Jail, credit for 92 days suspended, 6 days for a total of 48 hours of community service, fines and court costs in this case for a total of $625. Attend the MAD Victim Impact Panel within 45 days of sentencing, complete the earned DUI course within 60 days. And what we're going to do, ma'am, is continue testing. If you need to have someplace closer to you, then you need to do that. But you need to test when you're required to test. And the reason it's important to do that is because the ETG testing picks up certain days after drinking. And I cannot confirm that you, and Ms. McDuffie makes a great point. I can't confirm that you haven't waited a sufficient amount of time to show that there's no negative tests. So if you need to change your testing, you do that, but there are no more missed tests. And then I'll do a review. And I'm going to do it in 60 days. And if if you're testing negative at that time, then I'll consider removing the testing requirement. But until then, that's what I want to see. Okay.
Okay, and do you how would I be able to get a new location?
You can talk to the probation department about that. I'll see you back here on August 5th, 2024 at 10 a.m. to see if you've done what you're supposed to be doing and whether you're doing the testing. Okay?
Okay, sounds good.
You have the phone number for the probation department now?
I'm pretty sure I do, but can I get it again just in case?
Of course. 734 734-483
What was the last four?
7336.
Okay.
State of Michigan versus Terry Brewer, case number 23 FB 1224.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Terry Brewer.
Please state your name, sir.
Terry Brewer.
Thank you.
I have discussed all of Mr. Brewer's options, and I don't know if there's any offers from the people, but Mr. Brewer would like to set this for a final settlement conference.
We were actually already set for jury selection previously. This was sent back up. It was reauthorized with an additional felony charge for aggravated stalking, and it's now back down from there. So at the point or prior to that, we had submitted jury instructions, witness list, and I believe I submitted a notice as well. So Mr. Brewer had already rejected any offers. His offer had been to just plead as charged and the case to be and to have time served on the case, and it would have been closed out, but he did not want that. So we can proceed to jury selection. I don't know if you want to bench or jury, but whatever we're setting it for, we can proceed to that.
So were you able to proceed?
No, Your Honor. We can approach if needed. I don't want to say certain things on the record, lethality concerns.
All right, thank you.
Right here. No. Sorry, after the broad line. Transport the 1 acre 13 Smith and 1 acre right here. That's right. I don't have the cell phone with me. Oh, you got the cell phone. Yeah, I have a cell phone. It's not there. 248 573 95 Everything I use is on my phone. There's an income in my car, my dad's car. And they said my phone, then they told there's a lot of things going on that they pulled me over and told me I had a warrant 30 days ago. That's why they had me to do it. Then I could go back up to the court. They told me I got firearms charges. They didn't take me no firearms.
All right, I have had an opportunity with prosecutor as well as PD regarding this matter. And it appears that Mr. Brewer has a personal recognizance bond in this particular case, which is one of the things that this court was concerned about, given the time frame for the possible trial in this case. And the prosecutor wants to have a motion heard, file a motion, and have a motion heard, or according to the court's policy, will need to have a motion heard as to whether or not these matters will be able to proceed without any witnesses based on the fact that she believes that there were emergency circumstances ongoing at the time, and that the confrontation clause would not apply in this particular case. So we need to have a hearing as to those issues. So I'm going to do two things. Final settlement conference will be July 25th, 2024 at 11 a.m. Jury selection August 9th, 2024 at 8:30 a.m. And then we need to have an opportunity to hear the motion regarding whether or not the prosecution will be able to proceed without the witness in this case. And I can do those on July 1st or July 8th. Ms. McDuffie. Ms. McDuffie has to file the first motion, so you're muted.
Your Honor, that's correct. Although we also advise in the other cases that were similarly postured that I'm filing the motion, but I need to be advised of what's being contested in order to file it. So if in this case, pretty much the whole thing. So in other words, some cases have particular portions that would fall under that, and then some that wouldn't. And so defense was supposed to be advising the court and myself of, whether or not their objection was limited to any particular part. There's other cases where the whole thing is included. So I needed to know what exactly was being objected to so that I can write that. So if Ms. White can just give me a heads up. Either of those dates are fine, but I need to.
I don't understand in this case. You're telling us that you believe you can get her statements in. So you're trying to get all the statements in.
In this case, I think it would be pretty much everything.
So she's objecting to all of that. So I don't think there's anything that needs to be filed. You need to file your motion to explain to this court why you believe that those follow under are not part of the confrontation issue.
Oh, that's fine. I'm just clarifying that she is indeed objecting to all of it.
Yes.
Okay. Yeah, I'm good then. I just needed to know if it was a portion or part of it, because we have another case where it's sections being objected to.
July 8th, 2024, 11 a.m. for the motion.
Your Honor, can he get a nominal bond so that he has accruing credit?
There is a bond in this case.
Okay.
It's 5,000, 10%. So I think whatever you have is not comporting with what the court has. Ms. McDuffie.
Okay, I didn't realize it was 10% versus PR. I was told it was 5K PR, but I hadn't pulled it up yet. Thank you.
Thank you. Ms. McDuffie, please have your motions filed by June 24th. And responses need to be filed by no. One moment. By July 3rd. Thank you.
Thank you.
When they come, Mr. Brewer, can you have them come get you now, please? What is this? What's the name of Miss Moose? No, I figured it out.
Oh, okay.
Ask them to bring, can you please bring Miss Kristen Moose? Is that Miss Moose? Is that your client, Miss Saxon? You're muted, Saxon.
I'm sorry, I can't see her. Her name is blocking her face.
What's your name, ma'am?
Kristen Moose.
I think the PD's on one of them.
Court will call the matters of the state of Michigan versus Kristen Moose, 24 FB 1234, as well as 24 S00151.
Rachel McDuffie for the people.
Tina
Go ahead.
Tina Sachs on behalf of Kristen Moose for file 24S00151 SM.
Thank you.
Assistant Public Defender Sandra White on behalf of Kristen Moose for 24 FB 1234.
Thank you. All right, this case has some unusual history. Ms. Moose is back before the court today. I don't know, did she turn herself in or did she get picked up?
I don't know. You told her to turn herself in. And I believe I had last contact with her. She was supposed to turn herself in shortly after we had the motion hearing.
Ma'am, did you turn yourself in or did you get picked up? You're muted.
Ms. Moose, can you have the jail unmute you?
Nobody ever called me.
Ms. Moose, did you get picked up or you turned yourself in?
After I was let out of the hospital the second time, because I had to go back to the hospital the second time, I called and let them know where I was at and that they could come and pick me up, and they come and pick me up. So.
Because people ran for security. You get what I'm saying? She's just trying to that's looking at my house that I pay rent at.
All right, so we're here on the
apartment and Section 8 and all that can prove that. If she was messing with some other guy and had some other guy there, or she brought something to that house, she should be accountable for that. Because if they went to the house, they called her with something. That's something she had. She's trying to lie, trying to say that it's something that I had at my house.
I can hear the other hearing at the jail.
I didn't hear anything.
They're not, they're saying that I got.
all right, we're here on the pretrial portion. Then Ms. Moose has turned herself in or been picked up, whichever way we look at it.
Your Honor, Ms. McDuffie made an offer to me this morning while we were waiting. I need to be able to take this to Ms. Moose to discuss with her, so I'm asking for an adjournment on both parts of this case.
You want to adjourn it to next week when you come back next week?
I'm sorry, Your Honor, you broke up.
Can you come back next week on June 10th?
Your Honor, yes, I will. I may have to go in and out. I have a jury selection, but I'm not sure if it's going to go that day in 14A1. I'll just ask for your patience.
Okay. Of course.
Thank you. Will that be at 10 o'clock or later?
I can make it whatever time you would like, Ms. Saxon. What's time for you?
Later would be, as late as possible would be better.
All right. We'll make it 11 o'clock, okay?
Thank you. I appreciate it. Ms. Moose, I'll come see you.
Okay, thank you.
Bond is continued on both.
Thank you. Miss White, do you want her? She's leaving.
I'll go meet with her. Thank you.
Yeah, I'm getting ready to ask this person who they are first. There's a device labeled PCD63L, PCDP63L. Can you unmute and tell us your first and last name?
Aisha Jones.
One moment, please. The court will call the matter Ypsilanti Township versus Aisha Jones, 24T00188.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Aisha Jones.
All right, the defendant is here for a pretrial today.
Yes, Your Honor, I had a chance to speak with Ms. Jones. I believe I told Ms. Jones that I had not spoken with the prosecutor, so we didn't discuss if an offer was available, but Ms. Jones did indicate to me that she wanted to set this matter for final settlement conference. Is that still correct, Ms. Jones?
Yes, ma'am.
July 25th, 2020. 11 o'clock a.m. Jury selection will be August the 9th, 2024 at 8:30 a.m. That's in person, Ms. Jones. For the final settlement conference, you're muted. Bond is continued. You're all set, Ms. Jones. State of Michigan versus Gregory Corrigan, case number 24S00048.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Gregory Corrigan. Mr. Corrigan, can you state your name for the record, please?
Gregory Corkin.
All right. We're on a motion to suppress.
Yes, Your Honor. And if I just briefly could, before we begin that, could I approach on this matter? Thank you.
All right, we're before the court, and I have this motion here today. I believe that where we are with this is that the prosecutor has, well, the defense has filed their motion, the prosecutor has filed their response. Apparently, the court was sent a link last week to a video through evidence.com, but the court did not link that video to this particular motion to know that the court needed to review that particular video prior to ruling on it. The court does still need to review that video. Apparently, there was also an offer that has been made that Mr. Corrigan is considering, but apparently wants to wait to hear my ruling on this motion first. I will review the video to determine, one, whether or not Mr. Corrigan would be under the impression that he was, and I'm not sure if I have to review that again, whether that's the correct standard or not. I thought it was. Whether or not objectively one would believe that he was in custody at that time. But I will review the motion more closely and take a look and determine that and make a ruling on this case on July the 8th at 11 o'clock a.m. or as close to that time as possible that the case can be called.
Thank you, Your Honor.
You're welcome. I should also note that Ms. Mueller did ask me as to whether or not I have any conflicts given the history that Mr. Corrigan and I have, which I'm sure that he's thoroughly familiar with. And I believe that I can be fair, and I will look at this from the correct legal standard and make a ruling based on that.
Thank you, Your Honor.
You're welcome. Bond is continued, and I'll see everybody here on July 8th at 11 a.m.
Thanks, Your Honor.
Thank you.
Welcome. Have a good day, Mr. Corrigan.
You too.
State of Michigan versus James Williams, 22-00544.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of James Williams.
Sir, please state your name.
James Williams.
Thank you. We're here for a review and show cause. Last time Mr. Williams checked in and then signed out of Zoom before his case could be called.
That is correct.
I'm sorry, Ms. White, go ahead.
Yes, and Mr. Williams is here today. We did review the report. Mr. Williams is currently in the Accountable Choices program. Mr. Williams did do 9 months in jail on this matter. He is asking the Accountable Choices program, as the court knows, is 52 weeks. He's asking, since he did do that 9 months, if he could be discharged from probation.
Ms. McDuffie?
And Your Honor, I did forward to, I sent it to the general probation email on May 20th. We did receive a new warrant request for Mr. Williams. I'm just checking to see if it's been authorized yet. So that may play into things as well. That offense date was May 4th of this year. I don't know if the court has a copy. I only sent it to probation and I did not copy Ms. Ball, and I can forward it now.
I do not, and Ms. Ball's not here today.
Yeah, I can forward it to Ms. Sally as well. But just
well, the reality is my answer to that question is no.
Okay.
To the question of whether or not he can just simply be discharged.
All right. Mr. Williams, did you still want me to make the other request to the court?
Well, right now we're going to deal with whether or not there's a violation.
I'm sorry.
Yes, may take a minute to scan, but it's on the way.
Your Honor, I do see that report in here now. And I don't know if maybe I missed this, I just stepped back in, but there's also a new misdemeanor license ticket that would constitute a violation as well. I don't know if I'm repeating, Ms. McDuffie.
Oh, no, no problem.
Yes, I had a driving on suspended ticket. That's the warrant.
Mr. Williams, just a second.
We have a stop where it is alleged that they discovered a large Ziploc bag containing small baggies of suspected narcotics. Mm-hmm. That's when they found it. Mm-hmm. So are you saying that the narcotics has been authorized?
I'm checking now, Your Honor. It takes a while to pull it up on base. It looks like, sorry, this is so slow. This has not yet been assigned for review, so I can email the supervisor warrants right now and just let them know that it needs to be reviewed ASAP.
Okay. I'm gonna put this over to July 15th. See where we are with this in person at 11 o'clock a.m. Did he sign that again? No. We'll see you here in person, sir, on July 15th.
Okay.
Thank you. The court will call the matter of Devin Wilson, case number 20S00645.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Devin Wilson.
Ms. Wilson, please state your name.
Devin Wilson.
Thank you.
Your Honor, in this matter, I had submitted a competency order. I don't think I ever got a signed copy back.
I don't see a competency order in my file.
Looks like I submitted it on May 13th. I can send it over again.
One second. Let me go back a little further. Yeah, it looks like you're gonna need this. Wait, here it was signed and sent over on May 13th. I signed it the same day.
Okay, well, I'll be asking for an adjournment to get everything to the Forensic Center and to get a copy of that.
Adjourned to July 22nd.
And Your Honor, Ms. Wilson asked that I address bond.
Ms. Wilson was released to treatment and left treatment the same day. There's nothing to address.
I did explain that to her, but she insisted that I bring it up to the court.
I just wanted maybe another chance to go to a different facility, maybe one more fitting for me on tether for another chance. I mean, like I said, I met with Patrick. He sent over it.
Ma'am, I just said the request is denied because you talk doesn't mean that it's changed.
I mean that. Not even gonna say anything, ma'am.
July 22nd, 2024 at 9 a.m. for competency. Bond is continued. State of Michigan versus Joshua Dye, 22 FB 1265, as well as 20 W 004151.
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Joshua Dye. Your Honor, I wasn't aware Mr. Dye was in custody, but it looks like we're here on payments and he's being held on something else, if I'm correct.
Yes.
Okay. And his bond and what he's been held for is quite significant. So I guess we'd be asking for an adjournment.
September 16th, 2024 at 10 o'clock a.m. See where things are with Mr. Dye at that time. Good day, Mr. Dye.
Yep, you too.
State of Michigan versus Marco Bonacera, case number 20 FB 1691.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lipa for Mr. Bonacera.
Please state your name. Get them to unmute you, sir, and state your name.
Marco John Bonacera.
Thank you. Supposed to be here for sentencing in this matter. Mr. Bonacera, apparently there was confusion in how to not get to probation from the circuit court. Came down from circuit court, and sometimes they don't let us know that he's in custody so that probation can actually do the report. And apparently it didn't get sent to the probation department. We're trying to find out whether or not Mr. Bonacera could find someone to pay for his assessment, if so we could get the assessment done between this week and the 10th. If he has anybody that might be able to pay I think it's 130. Miss Straub, are you present still?
I am, Your Honor.
Is it 130 for the assessment?
It's 125, Your Honor.
25. And do we have any updates as to whether or not they can find someone to pay? Do you know?
I do not know about the payment. I do know that if payment is completed, that the report would be able to be done in time, but.
Okay. Mr. Lebo, have you had a chance to talk to him about that? Or you need a breakout room to do so?
If I could have a brief breakout room, Your Honor.
Right, we'll put you and him in a breakout room.
Thank you very much.
Thank you. This person is present. All right. We have an in-person, Mr. Andres Rijoas, that needs to occur. The court. Generally, if there's private counsel is here with him. All right. The court will take a brief recess to get prepared for that in-person matter. 1 second. 1 second. You may be seated. The court will call the case of the state of Michigan versus Andres Rijoez, case number 24S00143.
Rachel McDuffie for people.
Good afternoon, or good morning, Your Honor. Marshall Goldberg on behalf of Mr. Rojas, who's to my right. My P number is 35788.
Good afternoon. State your name, please, sir.
Andres Rojas.
Thank you. All right, we're here for a pretrial today, and the magistrate set this for an in-person hearing.
Yes,
Was that at the request? Was that at your request?
Your Honor, I think the reason for the in-person hearing in part is that my client has a very profound learning disability. He cannot read and write. He's been in special ed his entire time, and I think the concern of the magistrate was to make sure he understood things. I wasn't present at the initial appearance, but I've spent some time talking to him. I've received some records, educational and medical records that help me understand some of what's going on, and I've been in regular contact with his grandmother who's present in court. So I think that because of the learning difficulties, the court was being extra careful.
Gotcha. All right. And this is an allegation of an assault and battery upon Ms. Victoria Selby. What is Ms. Selby's relationship to?
She is his mother. And I gave her the Zoom information. I don't know if she was going to sign on because she wanted to be at least a participant in part on this.
All right. Ms. McDuffie, do you have any insight on this? At this point, we have no contact provisions in place except consensual, third party, and not to discuss the case.
I do actually, Your Honor. So I reviewed this case over the weekend, getting ready for today's docket, and I was a little bit surprised. I can't obviously speak for anybody else, but had I been the one to review it, I would have sent this straight to our restorative justice deflection initiative, which is the difference between deflection and diversion, just being that before anything is ever charged, we refer to restorative justice, and diversion being after it's charged. We do the same thing, but with the dismissal following. And based on the facts of this case, which I know the court doesn't have in front of it right now, based on the facts, the circumstances, and everything, I think this type of case is exactly what that program is intended for. And so upon seeing it, I still wanted to at least offer that option and go that route. And that is with me not knowing anything about Mr. Riojas', and I'm sorry if I mispronounced his name, sort of difficulties here. That's just me looking at the case on its face with who the parties are and what that relationship is and what was present in that report. So with that being said, I did reach out to Mr. Goldberg and try to explain that briefly to him. Obviously, he didn't have a lot of time to consider that, probably needs more background on what that is. I believe Ms. Wilson attempted to reach out to the victim, his mother in this case as well. I don't think they were able to have too much of a conversation just yet, but I'm under the impression that she is the one who retained Mr. Goldberg. So, and he has clearly been in contact with her because of the Zoom info.
That's not correct. He said that's not correct.
I was retained by the grandmother, although I did talk to the complaining witness, and she said she talked to a prosecutor yesterday. It was a different staff member, I'm sure. And she has expressed to me, and she was willing to join on Zoom to express it to the court, that she'd like to have contact with her son. He's going to remain with his grandmother, but she wants to be able to talk to him and have him have the ability to see his younger brother. But he's residing with his grandmother, who's present in court. She lives in Fowlerville.
Okay.
Meanwhile, my position, I did get the email. I saw it this morning. I'll put in the formal discovery request. I'm going to ask for another pretrial so that I can see what the discovery materials are and see what our posture is.
Okay.
And Mr. Goldberg, I was speculating about the retaining, but I think more specifically, but you do have direct contact with her because you gave her the Zoom information, correct? So you are able to communicate with her.
I contacted her last night, and I think she's in the parking lot. And may try to join on Zoom there if the court wants to confirm what I said.
There's nobody in the waiting room.
There is.
Right now.
Well, yeah, that being said, I can't have it. All that was just to say, obviously, I can't stop an attorney from talking to anybody, but feel free to, engage her in that conversation as well. I don't, of course, encourage that. So, Your Honor, yes, Mr. Goldberg does need to file an appearance with our office so that we can release discovery, and those conversations can take place. I'm sorry, what's her last name?
Seeley?
See, I didn't want, okay. She would have spoken to an advocate from our office. I would not have reached out directly just yet. I'm happy to speak with her. So if she has more questions about that program, she can speak to either of us. But we haven't had a full conversation yet, I don't believe, where she's had an opportunity to really learn more about that. So just so you know.
Your Honor, would it be helpful if I tried? She's sitting in a car with her niece.
I cannot tell you whether it would be helpful or not.
Well,
right now, I guess the reality is what we're looking to see if she's interested in and whether your client's interested in alternative resolutions, or you can look at the
I'm just
side. Let me finish, please.
Your Honor, just as it applies to issues of
Let me
bond
finish,
and
please.
contact.
Let me finish, please.
I'm sorry.
Or you can look into the issue of whether or not you want to proceed with the trial. As far as the contact is concerned, has the prosecutor spoken to, do you know if your victim advocate has spoken to her about contact with her son?
Your Honor, my understanding is that as the court mentioned, there's already consensual contact in this case. I think I saw it listed a few times in GIS at the arraignment. B, Ms. Wilson attempted to reach out yesterday, which I think is the call Mr. Goldberg referred to, but I don't think they were able to get very far in the conversation. So I don't know if contact was discussed or attempted to be discussed yesterday. But I did let Ms. Wilson know that just looking at the notes, we have a note in our file, and I believe that she either contacted the court prior to arraignment, but that request is, I saw it listed like 3 times over that she can have contact with him. So I think that condition's already been set.
I appreciate that. I didn't want to violate.
What I have is that it says consensual third-party contact. Let me see what the bond form says. It says consensual contact through a third party. She wants direct contact.
Yes.
Oh, I see.
And the ability for him to see his sibling.
So I think that, I don't know how we get her on the phone. You're saying she's in the, can you call?
If I had just a minute?
Yes.
Do you mind if I
No, I don't.
access my phone?
I see. It has it listed differently in a couple of different places. I see, Your Honor.
Yeah, I'm in the courthouse. They didn't have you in the Zoom waiting room. I can put you on speaker or have you try to enter on Zoom, whatever the court prefers. Hold on, please.
I prefer to have her come in on Zoom.
Do you know how to do Zoom from where you are? Yes. Now, but we're in here. the 41B website does as an information, right?
14B.
I do that, I'm sorry. I do all the time. Okay. Okay.
Oh, it's not on, the Zoom's not on the website. The Zoom's not on the website.
All right, let me give you the codes then.
Can she just come into the courthouse?
The doors are locked, but.
I can go get her.
All right.
Okay,
That's what they want.
thank you.
Okay, I'll meet her at the front door.
Meet the court officer at the front door, okay? Yeah, meet the court officer at the front door, please. Go to the front door. Oh, wait, you pulled out of the parking lot?
Oh, okay.
Let's stand by.
All right, I'm gonna pass this for a moment till she
She said
comes
she's 2
in.
minutes.
Okay, I'm gonna pass this and handle some
Sorry.
failure to appear as well. Wait on this. State of Michigan versus Jeremy Wardlaw for 24S00076.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Jeremy Wardlaw. I'm sorry.
Today's day and time scheduled pre-trial in this matter. The defendants failed to appear.
Unfortunately, Your Honor, I have also had no contact with Mr. Wardlaw. I would ask for a show cause.
Your Honor,
Response.
I'm sorry, go ahead, Your Honor.
I was just asking for your response.
Yes, Your Honor. I did see Mr. Wardlaw arraigned on this charge, and he seemed very coherent and aware of his court date. He has appeared before this court multiple other times in cases with the same victim. This particular case is not an assaultive charge, but I did advise Ms. White that there may be a potential other count added with threats, involving threats on there. Given that, I would request a bench warrant because I don't see any reason why Mr. Wardlaw is not here today.
Bench warrant to issue.
She pulled out.
$5,000, 10%. State of Michigan versus Chester Bell, case number 22S00951. Bless you.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lebo for Mr. Bell. And Your Honor, Mr. Bell is current on his payments.
Go ahead, Mr. Bell is what?
Current on his payments, Your Honor.
September 16th, 2024 at 9 a.m.
Thank you, Your Honor. And we are ready on bonus era.
Thank you. State of Michigan versus Marco Bonacera, case number 24FB1691.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lebo for Mr. Bonacera. Mr. Bonacera, could you have them unmute you and then state your name, sir?
Marco John Bonacera.
Thank you. All right, Mr. Lebo.
So Bonacera does tell me that he does have money that he could pay for the assessment with, however, he cannot access that while he's in custody, and that he is not aware of anyone who can provide that for him. We would like to address that, however.
You may proceed when bond.
Thank you, Your Honor. Mr. Bonacera does have full-time employment in Dundee at a company called Clean Tech, which is a recycling company. He has 2 children, 15 and 11 years old, that he has full custody and are currently staying with family. The most recent drug tests he attended were negative. He has told me and his prior attorney that he missed court because he moved, didn't have transportation, and truthfully forgot this case. He does tell me that he will be complying with any and all drug testing if released. Additionally, if the court deems it appropriate, he does have an address to be confined to his confinement tether.
I see he failed to appear on March 9th. He failed to appear on February 10th. I'm sorry, October 10th. So March 9th of 2020, October 3rd of 2023. Then his warrant was recalled at his request. And
I missed it.
then he missed the court date that he had set after the warrant got recalled. On November 7th. Then he bond was still denied because he wanted another withdrawal of that particular bond. He failed to appear again. So he just apparently he just keeps forgetting about this case 4 times in a row.
Your Honor, I believe that a tether would adequately assure Mr. Bonacera's appearance.
Ms. McDuffie?
In addition to the failures to appear for those court dates, I don't have any recent results, but it looks like he also had a history of failing to test. At least I'm looking at 3 missed tests in a row in November of 2023. I think that's the most recent one I have. I know that Mr. Lebo reported that his most recent tests were negative. But I just can't see that information. So I don't know why the court should expect that everything that's previously happened should change. I don't know that the tether is, if it really requires a tether being on his body to remind him that he has this case and has court, I think we have bigger problems.
He has an address he can be confined to?
He does, Your Honor.
What is that address?
Your Honor, if we could go off YouTube for that.